Do you understand? Let me rephrase that. Are you aware, sir, that the state of Wisconsin is represented by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, and Assistant District Attorney Zach Wichow? The three individuals seated to your left, my right.
Say the first part again.
Are you aware that the state of Wisconsin is represented by 3 attorneys here in court?
No, I do not understand.
Are you aware?
Not even aware.
So are you aware, sir, that the state of Wisconsin is the plaintiff in this case?
I'm not aware. This is where the confusion of that comes in. I have confusion to how the state can be the plaintiff.
I am not going to give you legal advice regarding that answer, sir, but you have the second amended criminal complaint, and if you don't, we'll give you the information as well. These are called charging documents, sir. And on the top of each one of those, on page 1, there's a caption. It says State of Wisconsin Circuit Court, Waukesha County. Do you see that?
Yeah, I see that.
Do you see where it says State of Wisconsin Plaintiff versus Darrell Brooks Defendant?
Okay. This is why I'm confused. You have every document I ever got up until this point was like this, with my name in all caps.
So what are you holding up? Is that the motion to withdraw?
Well, yeah, because it's the newest.
Right. So every legal document that is filed that's considered a pleading would have a caption. The caption is the information that says what court we're in. So it's circuit court, the county, Waukesha County, and tells the court who the parties are. The parties in this case are the state of Wisconsin as the plaintiff and Darrell Brooks as the defendant. Are you aware of that, sir?
No, I'm not. I need clarification on how the state of Wisconsin can be a plaintiff, because that would essentially mean that the state of Wisconsin is the injured party. How could the state be an injured party?
Sir, I am not going to go down this path of giving you legal advice. Are you?
I'm not asking for legal advice.
Right. And I don't need to
provide.
I'm
confused on how that can be. That's what I'm saying.
Well, the bottom line, sir, is the state of Wisconsin is the legal entity represented by the Waukesha County District Attorney's Office that brings charges against a defendant.
Alleged defendant.
Well, no, you're a defendant accused of committing offenses. You're not an
alleged defendant.
Well, no, you're a defendant accused of committing offenses. You're not an alleged defendant. You are a defendant, but the allegations are accusations. Are you aware of that?
No.
Are you now aware of it because I just told you it?
No.
Well, we're going to start with this premise, sir, that the state of Wisconsin is the plaintiff. They are represented in this case by the Waukesha County District Attorney's Office. There's many attorneys in that office, but the 3 attorneys who are prosecuting this case are the district attorney, Sue Opper, one of her deputy district attorneys, Leslie Basie, and an assistant district attorney, Zach Wichow. They have been seated at the other table, whatever courtroom we are in, throughout all of the proceedings, or the vast majority of the proceedings in this case. You're aware of that, right?
No.
You're not aware that these attorneys, these people seated to your right, have been in court virtually every time that you've appeared in court?
The guy just came like the last few court dates.
So you are aware because you made some observations.
Well, the confusion with the question that you're asking is still, how can the state of Wisconsin be the plaintiff?
I'm not
How
going to
could
answer
it be
that
the
question,
injured
sir.
party?
I have a different reason for advising you. And what you need to know, and what's important for my conversation with you today, is that the state of Wisconsin is represented by 3 attorneys.
Is that a judicial determination?
That is not. That's their prosecutorial discretion, sir. So
they're
but
the
what,
injured
hold
party?
on, nope. Let me ask you the questions and tell you certain things. What I want you to know is that the 3 attorneys appearing on this case have a collective, if I did my math right, 66 years of experience as attorneys. Did you hear what I said? Yes or no?
Okay, 66 years of experience as attorneys. Okay.
So I'm gonna ask them a couple questions, and I want you to listen carefully. Attorney Opper.
Yes, ma'am.
Has your entire career been as a prosecutor?
Yes, ma'am, since 1991.
How many intentional homicide cases can you estimate for this court that you've been involved in?
10.
That's just before me. Is that how you took that question, or is that total?
Oh, I'm sorry, total in the course of my career.
All right, so 10 intentional homicide cases that actually went to trial or just prosecuted in general. I wasn't very clear on my question,
That's
so
okay. I would say probably 8 of those would have gone to trial. This is a ballpark, Judge.
right. Suffice it to say, you are experienced in litigating intentional homicide cases.
Yes, ma'am.
You're also experienced in litigating reckless endangering safety charges.
Yes, ma'am, I've had many cases like that over my career.
How many trials do you think you've participated in over your 31 years?
I would estimate 200.
Attorney Basie, similar questions. You have, I believe, 27 years of experience.
I do.
All of that as a prosecutor?
Yes.
Can you estimate for the court how many trials you have been involved in?
125.
Very precise. Any of those intentional homicides?
Yes.
Any of those involve recklessly endangering safety charges?
Yes.
Now, Attorney Witchow, you're what we call the baby of the bunch. My understanding is 8 years of experience.
Yes.
All of that as a prosecutor.
Yes.
Have you been involved in an intentional homicide trial before?
No.
In addition, Mr. Brooks, first of all, did you hear the answers to the questions I just asked these attorneys?
Yeah, I heard.
I mean, you understand, sir, they have a lot of experience sitting at that table. Would that be fair to say?
Roughly.
Do you also understand, though, that they have at their disposal an investigator with the Waukesha County Sheriff's Department, meaning they're assigned, that person's assigned to the district attorney's office to help them, even during a trial.
During this part of the trial or the pretrial motion, where she's explaining to him all these things he's up against, it looks really, really bad to me for the state to go against one guy with all these advantages. So I looked into it, and basically your public defender pays the experts, and then at the end of the trial, they bill the state for all their expenses. In a case of this magnitude where you're representing yourself, how would Darrell Brooks even go about getting expert witnesses? And when looking into it, I found the Bradley Yawn case. Now, he is also representing himself pro se. He is now wanting to have a DNA expert check out the DNA evidence. And it's explained to Yawn that basically he has to file these motions with the court during these pretrial hearings to get the funds allowed for him to find his own expert witnesses. And while the judge denied most of the motions, he did approve $3,000 for Jan to consult with an outside expert and another $1,000 for those experts to review the findings of previous testing. But in the Darrell Brooks case, instead of listening, paying attention, doing what he was supposed to do, he thought he could argue his way out of the situation, probably get the case thrown out on some technicality because somebody said a word wrong. And even though he had a good old time doing all this, playing lawyer, it was still unfortunate for all the victims who had to sit in there and listen to him act like this. Ooh, that was much easier than typing all that. So now I'll let it get back to the court case.
I don't understand where we're going with this.
Just want you to understand the resources that you're up against when you represent yourself.
Doesn't make me flinch one bit.
And I'm not asking you whether you flinch. I'm asking you if you understand it.
I still go back to the question I asked. I don't understand how they can represent an injured party. How can the state of Wisconsin, the corporate state of Wisconsin, be an injured party?
I'm not answering that question. Okay, this is
So is that a judicial determination that you're not answering that question?
No, sir. This is a legitimate case, and I'm not going to make a mockery by you asking that question, because this case has been proceeding since November 23 of last year, and it's going to keep going on whether you understand how the state can be a party or not. Do I make myself clear?
No, because the question is still there. It's still a relevant question.
I'm telling you, I'm not answering the question, and whether you understand the issue or not is not going to stop this case from going forward.
So is that a rush to judgment?
No. So I also want you to be aware that the district attorney's office has available, because the case involves witnesses from the city of Waukesha Police Department, that they will have seated at the table behind them, currently seated now, Detective Tom Casey. Are you aware of that?
I'm still going to refer back to the question.
Sir, answer my question. First of all, did you hear me ask the question? Did you hear me? Yes or no?
No.
So I'm telling you, Detective Casey is going to be their court officer throughout this case. Did you hear me say that?
How?
In addition to Detective Casey being here, the district attorney's office also has a support staff member that will be available for their use during this trial. Did you hear me say that?
I'm still not understanding how there are questions not being answered.
Sir, did you hear me tell you that right now?
Did the court hear me ask the question of
Mr.
how can
Brooks.
the state be a plaintiff?
Mr. Brooks,
Is
gotta
it
answer.
some type
I'm
of
not-
case law you can point me
I'm
to?
not allowed to give you legal advice, nor will I.
I'm not asking for legal advice.
The whole point of this, sir, is that I need you to be aware that many people are going to sit on the other side of the courtroom working towards presenting this case and seeking convictions on all charges. Now, seated next to you are attorneys Perry and attorney Keys. My understanding of their experience, sir, is that Attorney Perry has been practicing for 20 years. Attorney Perry, is that true?
Yes,
All of that with the public defender's office.
that's right.
You have experience both now in the trial courts and appellate courts. Is that true?
Yes,
And throughout that experience, you have litigated intentional homicide cases.
I have.
Also been involved in, I would imagine, cases where the charges involve recklessly endangering safety,
Yes,
hit and run, resulting in death.
it's possible. I don't know.
Attorney Keys, my understanding is you have 12 years of experience.
Yes,
All with the public defender's office?
In criminal defense.
All in criminal defense. And you've been involved in intentional homicide cases as well.
Yes.
Suffice it to say, you and Attorney Perry have dedicated your careers to representing the rights of people accused of crimes.
Yes,
Take that job very seriously.
I do.
Attorney Perry, same thing, right?
Yes.
Mr. Brooks, did you hear me ask your attorneys about their experience as attorneys?
Trying to understand what is the relevance.
Sir, did you hear me ask them about their experience?
What is the relevance?
Sir, did you hear me ask them questions about their experience as attorneys? Yes or no?
What is the relevance, Your Honor?
Since you're questioning the relevance, I will presume that you heard me and understand that you are seated next to attorneys who have dedicated their careers to the representation of individuals accused of crimes, and that they're very experienced at that.
So you're assuming something that I did not say?
The other thing that I need to make sure you are aware of, sir, is what the state would have to prove in this case in terms of the elements of the offenses. I presume, but I want you to confirm that you understand the state of Wisconsin bears the burden of proof in a criminal case.
I'm not going to confirm anything until the question is answered, how the state can be a plaintiff.
I'm not going to answer that question, sir.
Can it be shown to me by some type of case law?
You currently have attorneys representing you. I have not discharged them. If you have questions about legal topics, you can ask them. I'll even give you a moment. I'll step off, give you a couple minutes, 5, whatever, if you need to ask them those questions. Do you want that opportunity?
We're on the record.
I can pause.
No need to pause. Can the prosecution?
Sir, we're moving on. I understand you're not happy with the court not answering this question that you have, but I'm not going to answer it.
Well, that's essentially a rush to judgment.
I'm not rushing to any judgment, sir. My concern here is to make sure that you understand the charges you face, the penalties that are associated with them, that you're aware of all of these things, that you are aware that you as a defendant do not have to prove anything at a trial. Are you aware of that?
I can't move past the rush to judgment.
There's no rush to judgment. Did you hear me, sir?
You just assumed that I said something I didn't say.
We're going to move on.
How can we?
We're moving on, sir.
How
Mr. Brooks,
can we do that, though?
we are here at your request to represent yourself. We're going to move on because your question is not relevant to that inquiry. So I'm moving on.
But it's relevant.
And you don't
for
have
me
to like it.
No, it's not. It's not that I don't.
We're moving
I'm
on.
fine. It's just I find it hard for me to ask a question that's not relevant, but then it's relevant for me to know the
Mr. Brooks, we're
experience
moving
of
on.
everybody
And
here.
if you have the inability to move on, then this hearing is done.
It still has to be a determination made.
Sir, I would like to
Ma'am?
continue. So we need to move past this. And if you can't move past this, then I'm done.
Then I can still make the record.
Sir, do you understand that
Do not.
the state of Wisconsin must prove each and every offense beyond a reasonable doubt?
No, I do not understand until my question is answered.
Sir, are you aware that
No, I am
the
not aware.
state, I didn't even ask the question. How
I'm
can you
not
answer?
aware.
Mr. Brooks, are you aware that the state must prove every element of each offense charge beyond a reasonable doubt in order for you to be convicted?
No, I'm not aware. The state still has, I'm still confused. How are
All
they?
right, Attorney Perry,
How could
Keys,
they be complaining?
we're gonna go off the record. I'm gonna take a break. I'll mute the live stream. I'll even stop it for now. I'm gonna clear the courtroom. I'm gonna give you some time to talk with Mr. Brooks. I'm not answering his question, nor am I required to answer his question, but I can't move past this
It's law from the
if
beach.
he is going to keep interrupting. He's not demonstrated thus far that he understands enough for me to even get past that to make a determination that he can waive his right to counsel.
So that's the end of this pretrial motion. And he doesn't say it don't make me flinch one bit. He says it doesn't make me flinch one bit. And maybe I've been watching this trial too much and the semantics are rubbing off on me, but that's the end of it. Thanks for watching.